Oops. How are you feeling, Mr. Strope?
A little bit better, Your Honor. Not
Yeah.
perfect, but a little bit better.
Well, none of us are perfect. So, okay, Mr. Labby, you're up.
All right. Good morning, Your Honors. Andrew Labby on behalf of Universal Property and Casualty. I'd like to reserve 3 minutes for rebuttal, please. Thank you. So I want to just start by addressing the issue raised by this court in its October 27, 2023 order related to a potential jurisdictional issue in that the plaintiff, John Sirinkis, was previously voluntarily dismissed from the action. And then the final judgment is listed as solely in favor of Mr. Sirinkis. And first off, apologies. Obviously, this is something that we should have caught earlier, so I apologize about that. It just, I just somehow overlooked it. But my concern is it does raise some jurisdictional issues with the court. The appellees filed a response where they essentially asked the court to hear oral argument, then relinquish jurisdiction for the trial court to correct what we perceive to be a clerical error in the entry of the judgment, and then kind of it come back. And I researched the issue and candidly could not find a case, discussing one way or the other. My concern is that I think technically that judgment would be void because it was entered in favor of a party over whom the trial court did not have jurisdiction. Because what the case law provides is once a party is voluntarily dismissed from the lawsuit, usually it's the defendants, but once a party is voluntarily dismissed, the trial court no longer has personal jurisdiction over that individual, and that a judgment entered in favor of someone over whom the court does not have personal or subject matter jurisdiction is void. So I'm not sure that the judge is going to be able to, I'm not sure if the trial court can simply amend the final judgment under 1.540A, or if a new final judgment has to be entered in favor of Paris Sirinkis, given that issue. And even if the trial court does...
Arguably, assuming it's a clerical error, then stylistically they would change it, as you pointed out, under the rule. And the problem is then it gets to come up again. And now everybody else has to do their preparation. Whereas had either party moved for a relinquishment of jurisdiction, corrected that, we might have been in a place to go forward.
I agree, Your Honor. I agree.
I don't realize it's easy for me to sit here with the benefit of hindsight being 2020. So take that, I understand. I'm not like you guys driving the car. I'm here somewhere else. But yes, I understand.
And I agree completely, Your Honor. And I'm not intending to be difficult for the sake of being difficult. My concern is that these type of jurisdictional issues typically are not something that can be waived by parties or not something that can be agreed to by parties. And my concern is if this court renders a decision after the final judgment is amended, is it open up to a party to challenge that based on the lack of jurisdiction? Because I'm not sure if the decision is based on briefing and argument.
Has anybody filed a motion to dismiss this case for lack of jurisdiction?
No, Your Honor. The only motion that was filed was by the appellees, which sought to have the court relinquish jurisdiction following oral argument so that the final judgment could be amended under Rule 1.540. And again, I'm not sure how that would impact jurisdiction if the court didn't have jurisdiction through oral argument and then subsequently obtains jurisdiction. If the final judgment is amended, does it then retroactively have jurisdiction over the...
Well, here's another possibility, is that judgment that's been appealed to us is a nullity and the action remains pending as to the other plaintiff, correct? I mean, that's possible.
Correct, Your Honor. And I believe if we are strictly interpreting the rules, I think that is what has happened here. I think that final judgment that was entered is void, and the case is still pending as to Paris Sirinkis, and a final judgment would need to be entered in her favor to then be appealed. And again, to Judge Casanueva's point, I agree wholeheartedly. We are here. We've briefed it. I'm, obviously prepared to address the merits. But I think that strictly speaking from a legal standpoint, that is where the case is, that there has not been a valid final judgment. So the appeal is subject to dismissal, and then there would need to be a final judgment entered in favor of Paris Sarinkis.
So we have two possibilities here. We have a nullity that's in front of us, theoretically, or we have a judgment that has a misnomer through a clerical error, oversight, whatever, that could be fixed to 1540 motion.
Correct. And yeah, I agree, Your Honor. I mean, I understand the and I mean,
that's an interesting thought too, because as I looked at this case yesterday, everybody is assuming that the plaintiffs are married. I'm not aware that there's anything in the record that says that the insurance policy just has their name. So there's multiple possibilities. They're married, they're brothers and sisters, they were divorced and now living together. And I couldn't tell last night because I kept going through the record to find the answer to that question, because under substitution of parties, under death, that rule 2B, number 2, subsection, that talks about the right to be enforced survives to the surviving plaintiff. And looking at the contract of insurance here, and it impacts the real estate, obviously, because you're insuring the land, I couldn't find the deed, and I couldn't find on the insurance policy that I was looking at whether, and I may have missed it, where the provision says, what happens if someone dies? And the next question that I raised up is, how do you file a dismissal when your client has passed away? What is your sort of authority to do that? I mean, I was going through a lot of stuff last night, and frankly, you know, it was like the second or third time, and my frustration levels went. And I was so glad to have you guys here come today, because now I can ask you all about this and share my frustrations.
Yes, Your Honor. Yeah, so as far as the substitution of the party, for whatever reason, that's not the route that plaintiff's counsel went below, and they instead voluntarily dismissed Mr. Sarinkis' action. As far as
the next two documents I saw in the pleading in the record following the filing of that had both names in it.
Yes, Your Honor, there is some caption issues, and even on appeal, obviously, we listed both plaintiffs erroneously. But as far as
I'll be quiet now, let the chief of the panel take over. I will, taken up a lot of your time already.
Yeah, let me tell you what I'm going to do. I'm going to say you used 5 minutes talking about this, and then I'm going to let you have your 20, because we had some other cases go short, and then I'll let Mr. Schroep do the same thing on the two topics. How's that?
Thank you, Your Honor.
Okay, so now your 20 starts on the merits.
Okay, great, Your Honor. As Your Honors are aware, this was a very straightforward case. It was an insurance claim related to a dock that effectively sank. The plaintiffs are obviously arguing that it was covered. Universal's position was that the cause of the loss was excluded because it was a collapse, and that's not covered under the policy. Went to trial. The jury was presented with the verdict form. One of the questions was, did the defendant establish by the greater weight of the evidence that the alleged damage to the dock was the result of an accepted or excluded cause of loss? And that's important. So it's the damage. Did the defendant meet its burden to prove that the damage to the dock was excluded or accepted under the policy? Now, originally, Universal's verdict form included language that said, if your answer to number 5 is yes, your verdict is for the defendant. So the jury would be aware that if they found that the damage is excluded, that's a defense verdict. During the charge conference, the trial court removed that language from the verdict form. And there was, a lot of discussion about it. And Universal's counsel said, so if the jury finds yes to number 5, if they find that the damage is excluded under the policy, it's not a finding for the defendant. And the trial court said it is a finding for the defendant, but the court enforces the finding. And the trial court went on to say that, the verdict form is asking the jury to make factual determinations on certain things. Factual determinations to damages, whether an exclusion exists. And then once they make all those decisions, guess who gets to sign the big judgment? Me. So he's saying that the jury is going to decide whether the loss is excluded. The jury is going to decide what the damages are, and then he's going to enforce that. What happened was the jury found that defendant met its burden to prove that the damage was excluded or was the result of an excluded cause of loss. And then during deliberations, they asked a question. They said, are we to decide how much compensation for the plaintiff? So as the trial court noted below, that's the jury saying, do we need to answer question 6, which is essentially what are the damages in this case? The judge told them to follow the instructions on the verdict form, which again required them to answer question 6. So then they wrote down $9,400. And just to address where that damages came from, because there was some discussion in the answer brief about the jury finding partial coverage. But during the course of the case, the jury was presented with 2 numbers, $22,000, which is the cost that the plaintiff actually spent replacing the dock, or $9,400, which was a repair estimate that was prepared shortly following the loss. Now, plaintiffs took the position below that the jury shouldn't award that $9,400 because essentially that guy came in and said, well, there was more work than I originally thought, so it would cost more than that to do it. But those were the 2 numbers presented. And in fact, in their closing argument, plaintiff's counsel even said, you have 2 figures. There's no other testimony. It's either $22,000 because the dock was less than a year old, or you also heard $9,400. However, that $9,400 that she testified to, they wouldn't honor it. There's more damage than $9,400. So the position by the plaintiffs below was always it's $22,000 or it's $9,400. The jury awarded the $9,400 after being instructed by the judge that they had to answer that question. This is not a situation where the jury, took an estimate and said, well, that's excluded, that's excluded, that's excluded, we're going to award X amount of dollars. They simply entered one of the 2 numbers that was available to them. Now, after that verdict was entered, both parties moved for entry of final judgment. Universal saying, well, Your Honor, you said that an answer of yes to number 5 is a finding for the defendant, so this is a defense verdict. This is a judgment in favor of the defendant. The plaintiffs argued that they should be awarded the $9,400, and ultimately the trial judge entered judgment in their favor for that $9,400. Now, the first thing I want to address is a little bit below, and certainly on appeal, appellees are attempting to turn this into a case of inconsistent verdict. And they're doing that because then they can try to take advantage of a technicality and say, well, you didn't object before the jury was discharged. But we are not taking the position that the verdict was inconsistent. We're not asking this court to do anything with the jury's verdict. We are arguing that it was error for the trial court to enter judgment in favor of plaintiffs based on the verdict as rendered by the jury. The jury clearly found that there was no liability. They found that there was no coverage under the policy. Therefore, it was error for the court to award damages. Now, this issue is actually
a brief inquiry here. We've done so many cases in the last few, and I don't want to misstate this record, so please help me out. Did Universal object to the jury verdict form or to the jury instructions after they were all done?
So we objected to the verdict form, to the removal of the language that said, if your answer to number 5 is yes, your verdict is for the defendant. We did object to that. The judge explained, no, they're going to find if there's an exclusion, they're going to rule on the damages, and then I'm going to enforce that. And again, so there's a lot of case law on this issue, where if the jury finds no liability and then awards damages, it does not support, and then lists an amount for damages, it does not support a judgment of damages in favor of the plaintiff. So we have the Continental Assurance Company versus Davis case out of the first DCA, where the jury found no liability, entered an award of damages. The trial court entered final judgment in favor of the plaintiff, and the trial court reversed with instructions to enter judgment in favor of the defendant, saying that the verdict does not support an award of damages. There's the Cloutier versus Central Contractor case out of the 5th DCA, where the jury found that the plaintiff did not perform under the contract, but then awarded breach of contract damages. And the court said that a special verdict which finds damages without finding liability, A, is not inconsistent, so that'll come into one of my other arguments, but B, does not support an award of damages. There's also a case out of the 4th DCA, Oliveira versus Ilion Taxi Aero Limited. That's a 2002 case, which is the same thing. Every court that has decided this issue, which based on what I found was the 1st, 3rd, 4th, and 5th, so every court but this one, has ruled on this issue and has held that if there's a finding of no liability and then an award of damages, it does not support a judgment in favor of the plaintiff. The case is very similar to one third DCA, which is Alvarez versus State Farm, which we cited to in our brief, where the court found that defendant proved its burden to establish a material misrepresentation under the policy, went on to award damages. Now, the difference in that case is that the trial court properly entered judgment in favor of the insurance company in that case, whereas here the court entered judgment in favor of the plaintiffs. But in analyzing the plaintiff's argument, the court said the jury found no coverage under the policy. The fact that the jury proceeded to award damages does not alter the outcome on appeal. So here we have the same thing that was present in Alvarez, in Continental Insurance, and all those cases I cited, where the jury found no coverage under the policy, they found no liability, they proceeded to award damages, but that does not support an award, a judgment in favor of the plaintiffs. The jury has to find that the defendant was liable, there was coverage under the policy, that the defendant breached the policy, which it didn't do in this case. So that's really the crux of the argument. This is not an inconsistent verdict case. It's simply the trial court erred in entering judgment based on the verdict as rendered by the jury. And just kind of factually, again, it's not an inconsistent verdict case. All that case law I cited stands for the proposition that a verdict which finds no liability and awards damages is not inconsistent. In fact, that Oliveira case out of the 4th DCA specifically says, a verdict of no liability which awards damages is not an inconsistent verdict in the sense that an objection must be raised by the defendant when the jury returns the verdict. It's just, that's not how it works. If it's no liability and they put a number down, that's not inconsistent. And that's what the jury found here. They also found that, again, that the damage to the dock was excluded under the policy. The defendant met its burden to prove that. That's not the type of definite finding which is mutually exclusive with a finding. Essentially what plaintiff's argument is, well, the verdict form for number 6 said, what is the cost to repair the dock at actual cash value? And if you go back to the jury instruction on actual cash value, it references covered cause of loss. But though it's not the type of definitive factual findings that would be mutually exclusive. In this case, just, maybe it would be different if the verdict form said, what are the damages resulting from defendant's breach, or what damages were due under the policy, or what are the compensatory damages due to plaintiffs. It wasn't anything like that. It was, what is the cost to repair the dock at actual cash value? So I don't think it meets the requirement of being mutually exclusive. And then just a side note, to the extent it was even inconsistent, I believe it would have been incumbent upon the plaintiffs to object, because the jury had found no liability. They had found the damage was excluded. They then listed a number because they were required to. And if plaintiffs wanted to take the position that based on that jury instruction of actual cash value, that rendered the verdict inconsistent, it would have been incumbent upon the plaintiffs to raise that objection before the jury was discharged. And that's exactly what the court said in Alvarez, that, the jury dutifully answered both questions as they were required to do by the court, which is exactly what happened here. And the homeowners did not raise any inconsistency objection. The homeowners cannot now complain of a compromise error in obtaining the damages in face of a verdict finding that there was no coverage under the policy. And that's exactly what happened here. They're saying, well, maybe they were finding partial coverage, which, as I discussed, isn't factually supported by anything. But if they believed that, then they would have had to have been the ones to object. The fact is that the jury found no liability, awarded damage, so that is a defense verdict. And if there was any inconsistency, then it would have been incumbent upon the plaintiffs to raise that objection. And then I guess the final thing I would just note is that COBA requires an objection to be made prior to the discharge of the jury. I would take the position that Universal's counsel was entitled to rely on the trial court's definitive ruling during the charge conference, that it did not have to renew its objection after the verdict was rendered, because it objected to the removal of that language. The trial court was very clear that a finding in the affirmative for question number 5 was a finding for the defendant, that the trial court would enforce it. And he was very clear that he intended for the jury to make factual determinations as to damages, as to whether the cause of loss was excluded, and that he would enforce it. So there would be no reason to renew the objection, which had already been asserted during that charge conference as to the verdict form. So because where the court is making a definitive ruling on the record, there's no reason to renew the objection. That's kind of the general rule in regard to evidentiary issues and things like that, and there would be no reason that wouldn't be equally applicable here. So for those reasons, Your Honor, we believe that the trial court erred in entering judgment in favor of the plaintiff in this case, and would request that the court reverse with instructions to enter judgment in favor of Universal. And I will cede the rest of my time unless anyone has any questions.
Thank you. Okay, Mr. Schroep, you want to spend a few minutes talking about the jurisdictional issue?
Certainly, Your Honor. Number one, I can confirm as a representation of the court that the Sarnakises were a married couple. The reason that they were dismissed, obviously there's, the substitution procedure, but obviously the reason that they were dismissed was a person died. I actually quoted, in the motion, a comment from the court at trial transcript, page 116. It was actually part of the trial transcript. And Mr. Salmon, who was appellant's counsel, answered the court's question and, worked for the insurer. Well, who's the actual plaintiff listed in this case? Is it the estate? And the appellant's counsel responded, no, it was John and Paris, and John we dropped as a party after he died. So in other words, that, it seemed to me that there was a certain amount of agreement implied in that, and so, I also think that the body of the judgment here has no error, and the actual remaining party is Paris. I think that what happened is when you look at the proposed judgment that the court signed, the court, probably an administrative person, recognized that one person had been stricken, and they just accidentally deleted the wrong name. And that's the kind of clerical error, inadvertence that the Rule 1.540A is designed to address.
Well, let me ask the question. I mean, there's no dispute, is there, that the proper name on the judgment would have been Paris, correct? No one
Actually, Your Honor, if you look at the brief, the initial brief of the appellant, they actually contend that the judgment was in favor of both. If there were seating from that, that's exactly what they say in their brief. So I think it's kind of hard for them to argue that they are in any way prejudiced or that there's any problem. But yes, Your Honor, the remaining plaintiff was Paris, and what happened is the style was incorrectly edited from the proposed judgment, and somebody, who knows who, just struck the wrong name. I think the court would readily. Well,
the reason I say is if everyone agrees it should be her, courts, appellate courts do relinquish jurisdiction for the lower court to correct a judgment pursuant to a 1.540 motion, and the parties would stipulate to that. It would, easy peasy. We don't have to have another appeal later if there's some issue. I'm just throwing that out there. And of course, Mr. Lobby will have a rebuttal in a minute, and he can say whether he agrees. But does that seem like a reasonable course to you, Mr. Schroep?
Yes, Your Honor. I think that would be the wisest course and the most conservative of judicial resources.
Well, I am wise, if not conservative, but.
Well, we would like to conserve.
I'm teasing you, obviously.
Certainly, Your Honor. And what I would say is that, that rule of civil procedure, obviously it's not a rule of appellate procedure, but the civil procedure specifically authorizes the court to do that during the pendency of an appeal. And I think that is a wise procedure in a situation where there's been, an obvious clerical error such as this.
Well, the case law, as I recall, when you have a 1.540 motion on other grounds, you're like, if there's a year limitation, that year is suspended if the motion is made within the year, but the jurisdiction has, the trial court's jurisdiction has been deprived because of an appeal, unless the appellate court relinquishes for the court to decide the motion.
Yes, Your Honor, that's what my motion was requesting. If
That's
it
what
was-
we could do. All right.
Does that adequately address that, do you think, Your Honor?
For now.
Thank you, Your
Okay,
Honor.
so you can start your answer argument now, Mr. Sherwood.
Thank you, Your Honor. Very much appreciated. The first thing I'd like to talk about a little bit is, one of the things that we've heavily emphasized in this case, throughout the case, after this jury verdict, was the actual cash value instruction. Because our side had a very distinct understanding of what it was intended to address. That it was intended to, explain how jury question number 6 was supposed to be calculated. And what it says is damage to covered structures other than screened enclosures that are not buildings shall be calculated at actual cash value, meaning the actual cash value of a loss to covered property that was actually damaged by a covered cause of loss, less recoverable depreciation. Now, in this case, we argued the dock was brand new. There's really, no appreciable depreciation. And what has happened in this case is that in the trial court, again and again, we threw down the gauntlet and said, look, this is the issue, and they refused to respond. So I really think that some of the arguments Mr. Labbe made, just were not made below because they refused to acknowledge the instruction. And I would note that even in the briefs, which, the initial brief, I think, was 9 pages, had 4 cases. The, reply, I think, was a little bit less than that and had 3 cases. I mean, they've not been, they didn't address this instruction head on. And I think that it's something they needed to do because it was really the primary feature of what we were arguing and our understanding. And I think that one of the most important documents that the court might want to take a look at is the remitter motion, because the remitter motion was the very first document that was filed by the insurance company after this, after this trial. And, one of the complaints in it was found in paragraph 24, where it said, this honorable court, being the trial court, clearly instructed the jury to only calculate damages measured on the basis of actual cash value. And then they quote the insurance policy, but it's quoted in the remitter. It's meaning the actual cash value of a loss to covered property that was actually damaged by a covered cost of loss, less recoverable depreciation. In other words, they said exactly what we believed was that, the way that the jury was instructed was intended to mean that they would only award, actual cash value damages for losses to covered property that were covered, that were damaged by a covered cause of loss. And, that was our understanding throughout the case. As a matter of fact, when the court was discussing jury instruction number 5, it talked about, its decision to strike that in reference to the special instruction, which was, the actual cash value instruction. So, we didn't view jury question 5 as really serving any particular question at all. And one thing that I noticed that Mr. Labbe was arguing, well, that it was some sort of collapse, well, that's not what the jury jury question number 5 said. It said, was it accepted and or excluded, an accepted and or excluded cause of loss? And my comment to that would be that essentially it looked to us like they were asking for the jury to review the entire, insurance policy and, determine, would perform the analysis of a coverage lawyer, and one of the things that the court said that they really have tried to avoid is the thing the court said to them is, if the jury makes this finding, you need to, argue to me what to do with it. So the idea that they guaranteed them a jury verdict in their favor, I don't think is accurate. We had an entirely different understanding. Our impression was the court was not impressed with jury question number 5. It did not think that it was well framed. The other thing is that exceptions, in insurance coverage parlance are often, something that's removed from an exclusion. So in other words, if, from a legal perspective, the question wasn't even well framed. And so they're relying upon this very questionable question. But even if you take it at the position most favorable to them, then that this was an accepted or excluded cause of loss, then you run head on into the definition of that actual cash value, which said that you only give cash value for something that was, for covered property that was actually damaged by a covered cause of loss. And that's really the fundamental problem we see, is that our understanding of the structure of these instructions, and by the way, these instructions, which were probably not the best, were ones that they requested. And it really put us in an untenable situation. So we're the ones that thought that we won this trial coming out of the jury verdict. They make no objection, which shocks us. And, they filed a motion for remittitor, which, by the way, essentially admitted that the verdict was in favor of the, was legally in favor of the, of the appellee. And, we really think that they changed their tune and came up with this argument kind of after the fact that, oh, this was always a jury verdict in our favor. As a matter of fact, one of the interesting things in the motion for remittitor is that they alleged all kinds of error on the part of the jury, including A, ignored the evidence in reaching a verdict or misconceived the merits of the case relating to the amount of damages recoverable. B, took improper elements of damages into account. C, calculated an amount that does not bear reasonable relation to the amount of damages proved in the injury suffered. And or D, the amount calculated is not supported by the evidence and is such that it could not be adduced in a logical manner by reasonable persons. So in other words, these things are not necessarily completely consistent with the whole idea that this was a verdict that was always in favor of, they did argue that the jury question number 5, but it just seems to me that they've changed their position. And, when they're asking for a judgment in their favor, it would be incredibly prejudicial to us, given that our understanding of the jury instructions and the fact that this special instruction, which was the basis of our understanding, was given at their request. So that's really a key, aspect of what we're trying to argue. The other thing, they principally relied upon the Alvarez case. And I don't think that case, or really many of the other cases, were inconsistent verdict cases. In other words, our position is here that you can't reconcile a finding of, that there had been a loss to covered property that was, resulted from a covered cause of loss, and, jury question number 5. And Alvarez, it was actually a very different matter where the accusation was that the homeowners made a material representation to State Farm by exaggerating the extent of the loss. What happened there is that the homeowners had attested to a loss in the amount of $82,000, and the jury found the real value of the loss was $6,000. And as the court is aware, a material representation voids coverage. And so therefore there was nothing inconsistent there. It was, it was completely, on point. And so that to me is part of the problem here as well. It's not an inconsistent verdict. It's not an inconsistent verdict. Well, if that's the case, why did they write an initial brief that, completely ignored the issues? I mean, that was something that I was sharply critical of. And we're also accused in the reply brief of, pounding on the table because we don't have any facts or law. Well, if we've been pounding on the table throughout this case, it was to get them to address the issue of the, of the actual cash value instruction.
Mr. Sharp, I've got a question on the motion for remittitor. The appellant argued or contended that the reason question 6 remained is in case something happened after the trial on appeal, and in order to avoid a retrial, we already had the amount of damages. Did the court, was there specific discussion during the jury instruction conference about that approach?
I don't believe so, Your Honor. what really happened is jury question 5 was dealt with a great deal of skepticism by the trial court. I mean, literally it said, if they make that finding, you argue, what it means. And while the court did say that it would be a finding for the defendant, it didn't say definitively what the legal consequences of that would be. And I think that it was fairly clear that the court was just concerned that it was a poorly drafted question. I have never seen a question that asks a jury to interpret an entire policy and, determine whether, some exception or exclusion. And, it was really, so what the court did is
there may have been a problem. There may have been a problem with question 5 as originally drafted. That issue isn't really before us. So we have jury question number 5. And typically, if the answer is yes, it's excluded, the case is over. The court went ahead and said, well, let's go ahead and leave question 6 in there, or let's add question 6. I don't remember all the details of it. But in the motion for remitter, as I said before, counsel for Universal contended that was only left in there for purposes of avoiding a retrial should there be a reversal on appeal. And I can think of another example. The court decides there's a directed verdict, that's reversed on appeal. There could be a number of things that result in savings by having that question there. So what I'm going back to is, did the court clarify why it was going to leave question 6 in there?
No, Your Honor, I don't believe it said anything about preserving it. As a matter of fact, I think the court thought it was superfluous. Because of the way it specifically mentioned the special instruction, which would have been the actual cash value instruction, which talked about, a loss to covered property from a covered cause. And the other thing that I would disagree with, Your Honor, is the statement that it found that an exclusion was applicable, because it used the words, actually the first word is accepted and or excluded. And one of the
but I will say the insurance company's denial letter, I think it referred to exclusions, but the policy does have language in it talking about exceptions or exclusions. I agree with you. Typically, it's an exception to an exclusion, but this policy had wording that said exceptions or exclusions. So I'm not sure that your argument's going to win the day on that in light of how the policy is written.
Well, let me posit a different potential outcome. I mean, one of the things that we've allegedly been criticized for is not disclosing that there was an estimate, of $9,400. Well, one of the things is that from what I was reading in the trial transcript, and maybe I have this wrong, is that was principally argued by the defense. And they actually argued at one point in time in the transcript that was a better measure of actual cash value than the 22, it was 28,000, and I think later in closing argument we asked for 22,000. So my response would be that one of the definitions of exception is something that's like set aside or something that's different than the other. And I think that what happened here is that the jury thought that we were asking for too much, that we didn't, that this was not actual cash value damages, but the $9,400 did reflect that. And they said, well, some of the damages they asked for, we didn't give, and therefore we answered yes. And I really think the real problem here, once again, is that, you really can't get past our actual cash value situation, because, I mean, it's perfectly reasonable to understand that why would you give an instruction as to actual cash value that instructs how to calculate it if it was not intended to be applied with regard to the verdict form? And specifically, it didn't say, it was actual, it was losses to covered property actually caused by a covered cause of loss. I mean, it's so, that largely informed what we were arguing. And, they confirmed it in their motion for remitter that was their understanding too. Obviously, behind the scenes, there's some negotiation that goes on about jury instructions. And when, we're trying to, when you've got parties that, when we understand, the purpose of their instruction as being, to cover that issue, and they claim, well, no, there's no inconsistency, there's no problem. We didn't think that jury question 5 was particularly well framed And we objected to it. And the trial court, took its own remedial measures, based upon, what defects it saw in the objection. But, what were we supposed to, our understanding seems very reasonable to me. And it seems that the court, understands the inconsistent verdict. If there was in fact an inconsistent verdict, then that would lead to a lack of preservation. And as COBA says, if there's an award of damages, then that the monetary award, then that means that has to be upheld. That it's not appropriate to render a verdict in the defense's favor when you have a situation like that. COBA is very clear. So that would be, and to be candid with you, even if they're part of what I think here is that when you look at the jury verdict form, 5 of the questions are answered in favor of the plaintiff, the appellee here. And I think that the reason that the defense chose not to do what the court instructed it to do and argue at that point in time what effect it should have, because you have the problem with jury question number 6. I think that they thought that the jury would not come back in their favor. And that's one of the things that's discussed in COBA is the strategically remaining silent. I mean, I think it's hard to make that argument as to the plaintiff when there was a large number of findings in her favor. I think that the jury, didn't, that this jury instruction number 5 had a number of different interpretations, some of which included partial coverage. I mean, we're not in the jury room. We don't know what they thought, but when you look at the instructions, oh, and by the way, it's worth noting that, one of the things they did in presenting, closing argument is that they had projectors. This I was informed of by trial counsel, and they had a verdict form up there that said $0. And they also made arguments that's referred to in my brief that said, we don't want you to award $2,000. We don't want you to award, we're looking for somebody that'll shut them out. And that's not what the jury did. And I really think that when you look at all those factors, the only conclusion is that they have strategically remained silent. Just one moment as I consult my notes, Your Honor, as to their argument. The other thing is, very briefly, that I don't think the jury instruction has the significance they contend. That actually, when a jury is asking about compensation, that typically favors, the plaintiff. But even then, nobody was in the jury room. We have no idea. They probably reread the instructions, would be the assumption. That's what the court instructed them to do. Were there any questions?
Doesn't look like it.
I yield my time.
Thank you, Mr. Schroep. Okay, Mr. Labby, what do you think about the jurisdictional question at this point?
Your Honor, I guess my feelings are this, and I don't argue, I don't contend that there's any prejudice to us by anything. Obviously, we were operating under the assumption that final judgment was valid the whole time. It just always gives me pause with jurisdictional issues like this.
I get it.
But if this panel believes that it can relinquish jurisdiction to have the final judgment amended and then issue an opinion based on everything that has been briefed and argued, then that's certainly fine. I genuinely enjoy arguing in front of Your Honors, but I have plenty others in the pipeline. So
not everyone feels that way. Okay. All right. So you want to start on your rebuttal on the merits?
Yes, Your Honor, thank you. So I want to address a couple of things. First off, this idea that that Universal kind of cooked up this argument on appeal. They filed a motion for remittitor and they filed a motion for entry of final judgment asserting so it's just alternative arguments, but we filed a motion for entry of final judgment based on exactly what has been presented to this court. So the idea that it wasn't something that was preserved below, it has no validity. They obviously didn't argue any of that in their answer brief either.
Mr. Labbe, I've one question relating to the jury verdict and the transcript. So following the return of the verdict, neither party raised to the court, judge, before you discharged the jury, you said you were going to consider the legal issues, legal argument. I mean, you agree that was not done. Nobody asked the court to do that.
Correct, Your Honor.
Right. All right. The second thing that struck me is the question that the jury posed right before the verdict came back is, are we to decide how much compensation for the plaintiff? It isn't how much is the value. Are we still supposed to determine some value, even though we ruled for the defendant? It is very specific. Are we to decide how much compensation for the plaintiff? Does that help us in analyzing whether or not this is an inconsistent verdict?
Your Honor, I think what the trial court said below, and which I believe is the only reasonable way to interpret that question, is they were just asking, do we need to answer question number 6? I mean, there would be no reason if they, and this kind of goes into what Mr. Schrapp was arguing, that, usually if they ask compensation, that favors the plaintiff. Well, I mean, I just think that position is a little ridiculous, because if they wanted to award money to the plaintiff, they simply would have filled out the answer to question number 6. There's no need to ask the question. The only reason they asked the question is because they rendered a defense verdict in response to question number 5. So they're saying, do we have to keep going? Because again, and that's a direct result of the court removing that language from verdict form, which would have said that this is a proceed no further or whatever language that it included.
But the removal of that language was not objected to.
It was objected to during the charge conference, Your Honor. Yes.
But not at the time of giving the instruction saying, we renew the objection, judge. We know you've ruled, but we think it's wrong and we need to preserve the record on that.
No, Your Honor, but I do believe that the trial court's ruling was definitive, and I don't believe that we were required to renew our objection to that. I mean, at the charge conference, he was very clear that it was, and again, the direct quote is, it is a finding for the defendant, but the court enforces the finding. And then he goes on to say, I want the jury to determine the damages. I want the jury to determine whether the exclusions apply. And then who enters the judgment? Me. And it kind of ties into it, and to Mr. Schraub's point, to Judge Silberman, your question about they didn't raise the argument. I mean, what the court is saying is not, after the jury returns a verdict, argue with me about how we apply that exclusion. He's saying they're going to find whether it's excluded, they're going to determine damages, and then after that, when you go to enter a judgment, you argue to me how to enter that judgment. He says, who gets to sign the big judgment? Me. He's saying that the jury's making those factual determinations, and he's the one who decides how to implement them. So the idea that he was saying raise these issues before the jury is excused, that's not what he was saying at all. He's saying, I decide how to enter the judgment after they make these factual determinations. And how did he enforce the jury's finding as to number 5? He gave no, it might as well not have existed. He just ignored it completely and entered judgment for 9,400. So we did argue to the court, just as the trial court wanted us to. We said, okay, this is a judgment in favor of the defendant. And the judge disregarded their answer to number 5 completely. And then just to briefly touch, but Judge Silverman, I know you hit it, but the idea that the verdict form, because it says accepted or excluded, there are exceptions in the policy as well as exclusions. I'd also just point out that number 5 says, did defendant prove by the greater weight of the evidence? So there was some reference in the brief about, sorry, I'm getting feedback. I apologize about that. About, well, they could have found that an exception to an exclusion apply, but it's clearly, did defendant prove by the greater weight of the evidence? We're talking about exceptions or exclusions. And while it doesn't reference the specific exclusion that was being argued, I mean, if you look at the closing argument and really the whole trial, we're talking about the collapse exclusion and that's implication. So I don't think that has any impact on anything. And, again, all the case law, Alvarez, Continental Assurance, Cloutier, Oliveira, it all holds that where there is a finding of no liability and then the jury goes on to award damages, that is a defense verdict. That does not support a final judgment in favor of the plaintiff. There was no finding of liability here. They found that the damage to the dock was excluded. They found that, they found that the defendant established by the greater weight of the evidence that the damage was excluded. And again, the idea that number 5 was somehow encompassed in number 6, it's the defendant's burden to prove the application of an exclusion under the policy. I think everyone agrees with that. Number 5 was absolutely necessary to make sure the jury understood the burden of proof. The defendant had the burden of proof that the damage was excluded. The jury found that it met its burden to prove that. And then it entered a number in response to number 6 only because it was required to do so by the judge's removal of the language in the verdict form. And also, because they asked the question, do we have to get that far? And the judge told them yes. It's hard to imagine any good faith argument that the jury was not attempting, did not think that it was rendering a defense verdict in this case. They made it clear on the verdict form. They made it clear by their question. And again, this is not an inconsistent verdict case. And this idea that we skirted the issues in our initial brief, I take issue with, because we are not asking this court to touch the verdict at all. We are saying the verdict as rendered by this jury is a defense verdict. They found that the damage was excluded. And again, I know I said it. Sorry, I thought that was just me. I know that in my initial argument, but if the plaintiffs thought that ACV, that actual cash value instruction, somehow rendered the jury's verdict inconsistent or ambiguous, it would have been incumbent upon the plaintiff to object. It was not incumbent upon the defendant to object where there was a finding of no liability in the case. So again, I would ask the court to join its sister courts in the 1st, 3rd, 4th, and 5th to find that when a jury returns a verdict of no liability and awards damages, that does not support a judgment in favor of the plaintiff. There's no appreciable differences between the rulings in the Alvarez case and Continental Assurance and all the other cases cited too, that would take this case outside of the realm of those holdings.
Thank you. Thank you both very much. Feel better, Mr. Schroep.
Thank you.
Thank you, Your Honor.
With that, we are adjourned. So in order to leave our courtroom, you click the leave button